Good morning, Your Honor. Paul, improper.
Ma'am, your name.
Good morning, Irina St. John, introvert.
Okay. All right, this is over attorney fees. You filed a counterclaim. He,
Your Honor, if I may address the court, which may expedite.
What starts as a seemingly routine dispute over unpaid attorney fees quickly turns into something much bigger. A seasoned divorce attorney claims breach of contract. His former client fires back with accusations of overbilling, unethical conduct, and legal malpractice. We've got arguments over expert witnesses, disputed billing before a contract was even signed, and a judge clearly signaling where the legal landmines are buried. The question is simple, but the answer isn't. Is this a lawyer enforcing his contract, or a client fighting back against what she believes is a deeply unfair system?
Matters. The principal case is breach of contract, Paul Schwab versus Irina St. John. The contract has been admitted in answer paragraph 3. In my complaint, I cited the contract. She admits it, so there's no question we have a contract. The only issue in my case in chief is the balance that is unpaid. I pled the pleadings, I pled the fees, and she said something to the effect of, well, they're unreasonable. So we'll litigate that. Her complaint is her counter complaint, as the court may be aware, is alleging everything that I could possibly do evil, including malpractice, legal malpractice. And she's saying, I want all my money back. Well, in our last pretrial conference, Your Honor cautioned her, Ms. St. John, you need an expert witness. And the witness filing deadline was November the 1st. She named her friend, Julia Belova, 30 years ago. That was stricken. She does not have a witness to support her counter complaint. And I have filed a motion waiting until the filing date is over with, giving her plenty of time to file before the date of trial. I have a motion pending to dismiss the counter complaint. She cannot prevail. She does not have an expert witness. She cannot testify as to the standard of care. She cannot testify as to reasonableness. Now, she just the other day filed another answer, and there's not one case cited. So she does not have an expert witness. She cannot prevail on a medical malpractice case.
legal malpractice.
Legal malpractice.
How are you going to prevail on that, ma'am?
Well, first of all, I would like to say that plaintiff filed his complaint on April 23rd. I filed my counter complaint on June 2nd. Plaintiff have plenty of time to file this motion. I'm following your pre-trial order, and it says, which was on July 29, 25, that no motion will be heard on the day of the trial. All motion needs to be filed no later than 20 days prior to the trial date, which plaintiff again goes against your order. Also, plaintiff cite his motion, he cite Michigan Rule MCL 600.2169, and this rule states that qualification of expert witness in action alleging medical malpractice. It doesn't say anything about attorney malpractice. So plaintiff.
You can't testify what the standard of care is because you're not an expert.
Yes.
I can't testify as to what the standard of care is for a orthopedic surgeon, a cardiologist. I know nothing about that. I'm not qualified. Neither are you to testify as to what the standard of care is or what he might have done wrong and that would subject him to a malpractice claim. That's your counter complaint.
My counter complaint about monetary damage.
I know it is, but how do you have monetary damage unless you have an expert here to say he cost her money because he didn't do something he should have done, because that's the standard of care. That's what a reasonably prudent lawyer would have done under the circumstances that was handling a divorce case. He would have had an appraisal done, or he would have had bank account records subpoenaed, or he would have asked interrogatories concerning the finances. Ma'am,
And I do have this in my brief, overcharging, that he overcharged me. He was charging me prior to signing the contract, which is and it's a big amount. It's all in my brief. That before we signed contract, he started to charge me for some preliminary work. I still was shopping around for the attorney represent me in my divorce case. I have multiple emails that I
okay, but
provided.
that would,
He said that if you decide to hire me on December 13th as your attorney, if you decide to proceed with me. So I didn't hire him as attorney, and he started to charge me thousands of dollars before I even signed a contract. Then he charged me for presence in my house for appraisal service.
look, I'm gonna cut this short. I'm not gonna strike her counterclaim now, but she's not going to be able to testify as to what the standard of care is with respect to a lawyer in handling of a divorce matter for you or on your behalf. I need to get off this bench for a few minutes, and my staff's entitled to a little break. I will come back in 10 minutes. We'll start the trial at 22, and I will ask you then to give your opening statements, okay? Thank you very much. All right. Okay. We're back on record, Schwab versus St. John, and of course I have a counterclaim 2501729. Your name?
Paul Schwab, improper.
Irina St. John in Brooklyn.
Okay. Any preliminary matters anybody needs to bring up? Besides what you already did?
No other matters, Sean.
Ma'am, anything you need to bring up? Call you, do you want to give an opening?
In real brief.
Okay, sure. You can have a seat, ma'am, and then you'll have the opportunity to give an opening, okay?
Your Honor, as indicated, this is a breach of contract lawsuit. There's no question as to the contract, its existence, its terms have been admitted. Answer number 3 to the complaint admits the contract. Sole issue in the breach of contract is the attorney fees, the reasonableness, the work that was done, and there will be an exhibit marked, a narrative detailed billing. It consists of about 6 pages of computerized entries at times and confirmations, very detailed. Testimony will also show in the case that these documents were given to the defendant, Miss St. John. There was never a complaint of overbilling, nothing. It'll show that Miss St. John changed attorneys and refused to pay the balance on the final statement. That led to the lawsuit. I anticipate that there will be some attempt to testify as to the counter complaint. And again, if history is any indication, that could be very lengthy as to the plaintiff. I anticipate a motion for directed verdict at the conclusion of the plaintiff proofs. And the court is aware there will be no expert testimony, and it just cannot prevail. At the conclusion of the court hearing, I will ask for a judgment of the amount of attorney fees and some of the costs and some of the interest. And that will conclude this matter. I anticipate my case may take 10 minutes.
Thank you.
Thank you, Your Honor.
Nan?
First of all, I would like to thank you, the court, for opportunity to represent myself in court. I believe in American transparency and justice of American court. Can I disclose the situation when Mr. Schwab called me during your proceeding and tried to negotiate with me? Can I disclose this information?
Settlement negotiations are really not admissible in the trial.
Yeah, so Mr. Schwab called me and he tried to negotiate with me. Can I disclose what he offered to me?
No, because settlement discussions are not part of the process, that they're not admissible.
Okay,
Okay?
I agree with this. Mr. Schwab just mentioned that he filed this motion to dismiss my counter complaint, and he stated that he 99% sure that you will dismiss this. I don't know why Mr. Schwab is so confident about this. We'll see. I hired Mr. Schwab on December 13, 2024, as an attorney to represent me in my divorce case with my husband, Michael Azell. I signed the contract at that day, at the end of our first meeting. Mr. Schwab overbilled me without my consent for $2,550, charging retroactive charges before I signed my contract. This is included in my counter complaint. He charged me for the days for the December 7th, 9th, 10th, 12th, and 13th before I signed my contract with him. I have exhibits of 2 letters from Mr. Schwab in which he's saying that if you decide to hire me on December 13th, we will sign a contract and I will explain you my attorney fees. According to the Michigan Court's Civil Proceeding Bench book about attorney fees, 8.6, it says that attorney-client relationship must be established by contract before an attorney is entitled to payment for service rendered. And also in the Michigan Rules of Professional Conduct, it says that a lawyer shall not make an agreement for charge or collect an unreasonable fee or unreasonable amount of expenses. I hired Mr. Schwab, experienced attorney, 55 plus years of practice. And I know that it's very unusual for client to file anything against attorney. And I have exhibit 2, which represent total 15 cases in the last 18 years that Mr. Schwab was suing his clients, and I'm one of them.
Okay, but why is that relevant?
It's relevant because I became a victim of his scheme when he intentionally overcharges his clients, then brings him to the court because he feels very comfortable in a court versus me, just a regular person. I'm a registered nurse. And then he overburdens the court with multiple motions. Like in my case, it's a motion, multiple 4 motions for frivolous pleadings. Whatever I did, following your court rule, I had the right to present a witness. I filed my witness list. I had the right to submit my affirmative defenses. I submit them. So everything was a frivolous pleadings. And he was asking for sanctions multiple times. So that's why this is his pattern. Overbills a client, file frivolous lawsuits for unpaid fees, request multiple sanctions, and enrich himself. So he's suing me for amount of $1,600, and everybody would say, you crazy, go to court and file counter complaint against your attorney, just pay this. And I made my informed decision that I'm not going to pay this because I firmly believe that it was grossly overcharged and overbilled. I presented in my counter complaint section by section that he overbilled me without consent for $2,000 $550. He coerced me for appraisal service of his choice, which was deficient and not admitted, and mediation by a mediator. Versus 1,000, he charged me $6,495, which I paid $3,570 for appraisal service, and all the rest, it was his middleman work and presence at my house for 3.4 hours as, I don't know, bodyguard or who. I don't know how it can be justifiable, charge someone attorney fees for being present at appraisal service. It's two independent men, they're working independently, they're doing their job, so I cannot justify this. Also, a financial discovery, $4,200, which what Mr. Schwab did, he filed interrogatories, which was grossly inefficient, contained only 13 questions, was very repetitive, so it was actually 4 questions. And they allowed my husband to answer very vague and did not provide any substantial information. And also his unethical behavior, a failure to follow own contract, which according to his contract, I had a due date to pay my balance 14 days. He filed a complaint with this honorable court 7 days before the due date. That's all in a contract. Also, he disclosed my personal information with my present attorney, Michigan law. He sent them his statements from his answer to my complaint to Michigan Grievance Attorney Commission. Mr. Schwab knows that I represented myself improper here, and with that case, I don't know why he sent the whole package to my attorney. So he was very surprised too. And also he disclosed some confidential information with my husband when my husband called him. He called me a psychopath. He disclosed some information about my Ukrainian family, and who knows what else he disclosed with him. That could damage my case also. So I'm asking the Honorable Court and you, Your Honor, to help me, with this case, because I think it's very grossly overbilled, and Mr. Schwab did a lot of mistakes. That's why I asked you to reward me $10,000 that I paid for a case that just started in Mr. Schwab's case, and dismiss his complaint with prejudice.
Thank you. Call your first witness.
Your Honor, I'll call on Rita St. John.
Okay. Ma'am, you can come right up to the witness chair here, okay?
You can walk right in. Grab that ramp right to show me.
Yeah, right up here. Okay. Raise your right hand. You solemnly swear or affirm the testimony you will give in these proceedings will be the whole truth, so help you God.
Yes, I swear, I do.
Okay. Have a seat, please. You may proceed, Mr. Schwab.
Could you state your name for the record, please?
My name is Irina St. John.
And where do you live?
I live in Grossville, Michigan.
And who do you live with?
I live with my husband, Michael Lazell, and my daughter, Elizabeth St. John.
Is there a divorce complaint pending with your husband, presently?
At the present moment, my divorce is, we filed the motion for dismissed of the divorce on November 5th.
So he dropped the lawsuit against you. The divorce is over with, right?
Yes, we
Mary.
decided to preserve the family.
Do you remember contacting me December the 5th, 2024? Your first call to me?
It's hard to recall, but I recall it, yes.
Yes. You were referred by a mutual friend, weren't you?
We don't have any mutual friends.
Olga? Olga,
That's your former client. She was not my friend, I never met her.
she lives in the same apartment complex as your mother and your brother, right?
I never met you in my life.
We spoke that day, didn't we?
We had a conversation on the phone, yes.
You told me that your husband told you he has filed for divorce.
I said that I think my husband filed for divorce.
You were upset, weren't you?
Or wouldn't you be upset?
Okay, just answer his question. Were you upset?
Yes, I was upset. I was shocked.
I offered, you didn't have a copy of the complaint, correct?
Of course, because he didn't file at that moment.
And I offered to go down to the Wayne County Court, see if there's a divorce complaint filed, correct?
On December 5th, no, I don't recall that.
Did I go down to see if there was a divorce?
I don't know where if you did or not.
That worked. First telephone call, the visit to the court, the telephone call to you to tell you there is no complaint filed, to talk to you more about your daughter. I didn't charge you for any of that, did I?
I don't know, it states a chart in your, does it say anything?
I'm gonna show you what's been marked as exhibit 8. John, to introduce this is offered as the billing statements for my work representing, there are 2 statements, one dated February the 28th, the second April the 16th.
Of 25,
Those,
of 25, correct?
April, yeah, 25,
And is that marked plaintiff's 1,
exhibit 8.
8?
A.
Exhibit A is an apple.
Good enough. You may approach the witness.
Look at the first 4 entries on that statement. Dated, the entries are dated December the 5th, December the 6th, December the 7th. Any charges for that?
According to your contract, no, it says no charge.
You continued to talk to me, didn't you, after that? You called me. I called you.
I talked to few attorneys, yes, I was searching for a
No,
good
I'm asking
attorney to
you, me.
represent.
To me,
Yes, I still talk to you.
right, and you
Yes.
talked to other attorneys,
Yes, and I talked to another attorney.
right, and you hired me, didn't you?
I hired you on December 13, 2024, when we signed the contract at the end of our meeting. This is when I made my decision. Yes,
You received a copy of this billing dated February the 28th. You received it by email on February the 28th, didn't you?
I received this, I signed the contract on
No, no,
December
question.
13,
Listen to the
24,
question.
and I received your first invoice on February 28.
That's what he asked.
Yes, 25.
Yeah.
Against your promise, send me a monthly billing every month. Right?
You,
So 3 months later, yes, I received your first invoice, that's correct.
did you object to this billing when you received it?
Can I clarify this?
Yeah.
So when I received this first invoice, we had a very hot, how many hours conversation regarding stagnated discovery? It should be in his bill. 90 minutes, so it's the last page. It will be, oh no, it's 2 here, so it will be end of the first invoice. Page,
This is where the case stops being just about money and starts becoming about credibility. The defendant isn't only disputing numbers, she's alleging a pattern of behavior, questioning billing practices, discovery strategy, and even professional ethics. From a legal standpoint, though, the judge must separate what feels unfair from what can actually be proven in court. Patterns, accusations, and frustration may resonate emotionally, but the law demands evidence, relevance, and admissibility. So here's the real question for viewers. If you were in her position, would you fight on principle or cut your losses and walk away?
page 3, it will be hour and 20 minutes phone conversation on 2/28/25, when I was the first complaining about stagnation of my discovery. So at that point, it was almost 3 months and nothing was done. The answer to my complaint was never filed. It was filed 123 days after the due date. It actually was filed on April 15.
What?
Discovery was not
What was filed on April?
the answer
Complaint.
to complaint, to my husband's complaint. So it was 123 days overdue.
All right, but that's kind of customary in the practice for lawyers to get extensions. So I'm just telling you, you didn't go into default at all, right?
It could go to the.
Yeah, but you didn't go into default.
It didn't.
Okay.
Lucky for me. So the discovery was in stagnation, and I was asking Mr. Schwab what we can do. So
At its core, this case highlights the tension between legal contracts and client trust. The judge made it clear that while concerns about billing and representation can be raised, malpractice claims live or die by expert testimony and procedural rules, whether the final ruling favors enforcement of attorney fees or limits the counterclaim. This courtroom battle underscores how critical clarity, documentation, and legal standards are on both sides of the aisle. If you found this case as intense and thought-provoking as we did, hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns you won't see anywhere else.